You're stone cold sober, haven't touched a drop. You get pulled over for a broken taillight, and 20 minutes later, you're in handcuffs facing DUI charges that could destroy your career, your finances, and your freedom. How does that happen? Because you made one critical mistake during the stop. Actually, you probably made 5 mistakes. And every single one of them handed the officer exactly what they needed to arrest you, despite your complete sobriety. This exact scenario plays out every single day across America. Completely sober drivers cooperate their way into jail cells because they don't understand that DUI stops aren't about determining actual impairment. They're about systematically manufacturing probable cause through psychological tactics that police are explicitly trained to deploy. I've personally analyzed over 400 DUI case files from courts across this country. I've reviewed countless hours of police body camera footage showing these exact tactics being successfully used on innocent people. I've studied the actual police training manuals that teach officers step by step how to build arrest justification, even when drivers are demonstrably and objectively sober. And through all that research, I've identified 5 specific tricks that lead to the most wrongful arrests of people who never should have been charged with anything. These aren't conspiracy theories. These are documented tactics taught in law enforcement academies and deployed during traffic stops every night in every state. What I'm about to show you is how police turn your cooperation into evidence, your honesty into confession, and your constitutional ignorance into conviction. Before we go any further, understand something. If you drive, if you ever get behind the wheel of a car, this information could be the difference between going home and going to jail. Not because you did anything wrong, but because the system is designed to extract incriminating evidence from people who don't know their rights. Subscribe to this channel right now, because what you're about to learn isn't taught in driver's education. It's not explained when you get your license. And it's certainly not volunteered by police during stops. This is the legal framework that protects you when officers are systematically trying to build a case against you. And most Americans have no idea it exists. Hit subscribe, turn on notifications, and commit to understanding the constitutional protections that exist specifically to prevent this kind of abuse. Millions of people every year get arrested, charged, and convicted for DUI when they weren't impaired, and the only reason it happens is because they didn't know what you're about to learn. Don't be one of them. The first mistake happens before you even hand over your license. The officer walks up to your window and asks a question that sounds casual, almost friendly. Have you had anything to drink tonight? Seems innocent. Seems like honesty is the right approach. You think admitting to 1 beer 3 hours ago shows cooperation, demonstrates you have nothing to hide, and helps the officer understand you're not impaired. That's not what happens, not even close. Here's the legal reality that nobody tells you. The moment you admit to any alcohol consumption, doesn't matter if it was 1 beer, half a glass of wine, 3 hours ago, 5 hours ago, you have given the officer reasonable suspicion to extend the stop, detain you longer, demand field sobriety tests, and escalate this entire encounter into a full DUI investigation. That admission is the foundation. Everything that follows builds on those words coming out of your mouth. And it's all being recorded on body camera footage that goes directly into the police report and straight to prosecutors who will use your own statement to establish that you operated a vehicle after consuming alcohol. Defense attorneys have a term for this: admission against interest. You volunteered evidence that the state uses to convict you. Police training manuals explicitly teach officers to ask about alcohol before requesting your license and registration. Why? Because if you admit drinking first, the legal threshold for everything that follows changes completely. What started as a routine traffic stop for a broken taillight or a lane change without signaling is now officially a DUI investigation. The officer can justify extended detention, they can demand multiple tests, they can call backup, they can separate you from passengers and search your vehicle. All because you answered a casual question honestly. The psychology is deliberate. They ask before you're on guard. They make it sound conversational. They bank on your instinct to cooperate with authority. But here's what you need to understand. You have zero legal obligation to answer that question. The Fifth Amendment protects you against self-incrimination, and that protection applies the moment a traffic stop begins. Pennsylvania versus Muniz established that officers can order you out of the vehicle for safety reasons, but they cannot compel you to answer interrogation questions. Your silence on that specific question cannot be used as probable cause for anything. So here's the exact dialogue you use. Officer asks, "Have you had anything to drink tonight?" You respond calmly and clearly, "I'm not discussing my day, officer." If they push back with, "It's a simple question," or "Just answer the question," you repeat the exact same phrase, "I'm not discussing my day, officer." If they escalate with, "Are you refusing to cooperate?" you say this, "I'm happy to provide my license and registration. I'm not answering questions." That's it. You're not being hostile. You're not being combative. You're exercising a constitutional right that exists specifically to prevent self-incrimination. And critically, you're not giving them the foundational admission they need to turn this into a DUI case. But understand something. Declining to answer doesn't prevent the officer from observing your behavior, your appearance, or deploying the next tactic in their playbook. The second mistake is performing field sobriety tests. You've successfully refused to answer the drinking question. The officer shifts tactics. They say something like, "I need you to step out of the vehicle and perform some standard tests to make sure you're safe to drive." Most people hear that and think cooperation proves innocence. They believe walking a straight line and standing on one leg demonstrates sobriety and gets them sent home. That's a dangerous misconception built on complete ignorance of how these tests actually work. Here's the legal reality. Field sobriety tests are completely voluntary. The officer is asking, not ordering, even though they phrase it like a command. And here's the part that should make you furious. National Highway Traffic Safety Administration research shows that the walk and turn test is only 68% accurate. The one-leg stand test is only 65% accurate. That means 1/3 of the time, these tests fail to correctly identify sober people. You can be completely sober and still fail because you're nervous, because you have a physical limitation you don't even realize affects your balance, because the pavement is uneven, because the lighting is poor, because you didn't understand the instructions fully, or because the officer subjectively interprets your performance as failure. And here's what makes this systematic abuse. Officers are trained to look for failure cues. Your foot comes down at 28 seconds instead of 30 during the one-leg stand. Failure clue. You take 8 steps instead of 9 on the walk and turn. Failure clue. You ask for clarification on instructions. That gets noted as confusion, which gets interpreted as impairment. These tests aren't designed to clear you. They're designed to document reasons to arrest you. The officer has already decided you're going to jail. The tests are just the evidentiary justification for a decision that's already been made. Body cameras capture your performance, but they don't capture the context. They don't show whether the officer gave clear instructions. They don't document that you have a knee injury that affects balance. They don't record that the test was administered on a sloped surface in violation of NHTSA protocols. Juries see you stumbling on video and assume guilt because they don't know what you now know. These tests are designed for you to fail. Courts have repeatedly found that officers deviate from standardized protocols, rendering the tests even less reliable than their already terrible accuracy rates. But none of that matters because you volunteered to perform them. So here's the exact dialogue. Officer says, "I need you to perform some tests." You respond, "Officer, are you asking me or ordering me to perform these tests?" This forces clarification. It's a yes or no question. If they say ordering, you follow up. For the record, what's the lawful reason for ordering physical tests? I want to comply, but I need to understand the legal basis. Then you clearly state, "I respectfully decline to perform field sobriety tests. I'll comply with chemical testing as required by law, but I'm declining voluntary physical tests." If they were asking, not ordering, you simply say, I respectfully decline. Why does this work? Because field sobriety tests are not required under any state's implied consent law. Implied consent, the law that says you agree to chemical testing when you get a driver's license, only applies to breath or blood tests after arrest. It doesn't cover voluntary roadside physical tests before arrest. You cannot be penalized for refusing field sobriety tests. And without your voluntary performance, the officer loses a massive piece of evidence they need to establish probable cause for arrest. But declining field tests doesn't stop the next tactic they deploy. The third mistake is taking the roadside breath test before you're arrested. You've declined field sobriety tests. The officer pulls out a handheld device and says, "Just blow into this real quick to make sure you're under the limit." Sounds reasonable. Sounds like this will clear you and you can go home. It does the exact opposite. Here's the critical legal distinction that most people don't understand. There are two completely separate breath tests in DUI law. The preliminary breath test administered at roadside before arrest and the evidentiary breath test administered at the station after arrest. These are legally distinct, governed by different rules with different consequences, and confusing them can destroy your case. The roadside preliminary breath test, called a pass test in most jurisdictions, is voluntary in most states for drivers over 21. It is not covered by implied consent laws. It exists solely to establish probable cause for arrest. The results are not admissible in court to prove your actual blood alcohol content. This is a screening tool used exclusively to justify taking you into custody, and these portable handheld devices are notoriously inaccurate. They're not calibrated as frequently as station equipment. They produce false positives from mouth alcohol residue, mouthwash, acid reflux, even cold temperature affecting the sensor. But officers don't care about accuracy, they care about justification. Even if you blow a 0.03, well below the 0.08 legal limit, the officer writes in their report, "Subject registered positive for alcohol." Prosecutors use that language to argue impairment regardless of the actual number. The number might not be admissible, but the fact that you tested positive gets used against you. This is how the game works. Officers make the preliminary breath test sound mandatory. They say things like, "I need you to blow into this," or "State law requires a breath test." Both statements are misleading at best, deliberately deceptive at worst. State law requires breath testing after lawful arrest under implied consent. State law does not require preliminary roadside screening before arrest. They're banking on your confusion between these two legally distinct tests. So here's the exact dialogue. Officer demands you blow into the roadside device. You ask, "Is this a preliminary screening test or an evidentiary test after arrest?" Force them to clarify. If it's preliminary, you say, "I respectfully decline preliminary testing. I understand I'm required to submit to chemical testing after lawful arrest, and I will comply with that legal requirement." If the officer threatens consequences, license suspension, refusal charges, you respond, "Implied consent applies to post-arrest chemical testing, not preliminary roadside screening. I will comply with all legal requirements after arrest." Why does this work? Because most states legally differentiate between voluntary preliminary tests and mandatory post-arrest tests. California Vehicle Code 13353.1 clarifies this distinction explicitly. Nevada Revised Statutes 484C-160 confirms it. Texas Transportation Code 724.011 codifies it. You cannot be penalized for refusing preliminary breath tests before arrest. The penalties for refusal only apply to evidentiary testing after you've been lawfully arrested. Declining the roadside breath test prevents the officer from manufacturing probable cause through a notoriously unreliable device. But even if you've protected yourself from the drinking question, refused field sobriety tests, and declined preliminary breath testing, officers have another tactic that catches people who did everything else right. The fourth mistake is consenting to a vehicle search. You've handled everything correctly up to this point. The officer is visibly frustrated because you're not giving them what they need. so they shift tactics completely. They ask, "Do you mind if I take a quick look in your vehicle? If you've got nothing to hide, this will only take a minute." Most people consent because they believe refusing makes them look guilty. They think saying no raises suspicion. They think cooperation means giving permission to search. Officers count on this misunderstanding of your constitutional rights. Here's the legal reality. If an officer asks permission to search your vehicle, it's because they don't have probable cause or a warrant. Think about that. If they had probable cause, if they had legal justification to search without your permission, they wouldn't be asking. The question itself reveals they lack legal grounds, and your refusal cannot create probable cause. Rodriguez versus United States makes this absolutely clear. Officers cannot extend traffic stops to conduct searches without reasonable suspicion of criminal activity. Asking for consent is their way of bypassing Fourth Amendment protections. Your consent eliminates the constitutional barrier. Once you say yes, anything they find becomes admissible evidence, and that includes items that aren't even yours. Maybe a friend left something in your car. Maybe the previous owner left something hidden under the seat. Maybe you have prescription medication that looks suspicious to an officer who wants to escalate this into an arrest. Consent transforms a routine traffic stop into a fishing expedition where officers search for anything they can use to justify taking you into custody. The psychology is sophisticated. They ask casually, like it's no big deal. "You don't mind, right?" Or, "This'll just take a second." They make refusal seem unusual, suspicious, like you're hiding something, and they keep asking after you say no. "Are you sure? What are you worried about?" It's intentional intimidation designed to wear down your resolve and get you to cave. Here's the exact dialogue. Officer asks to search your vehicle. You say 9 words. "I do not consent to searches, officer." If they ask why not, if they say, "What are you hiding?" or "If you've got nothing to hide," you repeat the exact same 9 words. "I do not consent to searches." If they threaten to bring a K-9 unit, you add one critical question. "I do not consent to searches. Am I free to leave?" That final question is legally important because Rodriguez established that officers cannot extend traffic stops to wait for drug dogs without reasonable suspicion of criminal activity. Why does this work? The Fourth Amendment protects against unreasonable searches and seizures. Courts have repeatedly held that refusal to consent cannot serve as the basis for probable cause. Without your consent, the officer needs specific, articulable facts that create probable cause. A much higher legal standard than just asking permission and hoping you don't know your rights. Never consent to vehicle searches during traffic stops. Cooperation doesn't mean sacrificing constitutional protections. You can be polite, calm, and respectful while absolutely refusing to give permission. But even if you handle everything perfectly at the roadside, even if you don't answer questions, don't perform tests, don't blow into devices, don't consent to searches, if you still get arrested, there's one final mistake that destroys your entire defense before you even see a lawyer. The fifth and final mistake is answering questions after arrest without invoking your right to an attorney. You're arrested. You're at the police station. The officer seems friendly now, almost sympathetic. They say something like, "Look, I'm just trying to figure out what happened here. If you explain your side, we can clear this up." You think honesty helps. You think explaining that you weren't drinking, that you're not impaired, that this is all a misunderstanding, you think that gets you released? It doesn't. It destroys your case. Here's what people don't understand. The arrest already happened. The officer isn't investigating whether to arrest you. That decision is made. What they're doing now is building the prosecution's case. They're collecting statements that will be used against you in court, and every word you say becomes evidence. Miranda rights apply once you're in custody and being interrogated. But here's the critical part that most people miss. Miranda only protects you if you actually invoke it. Berghaus versus Tompkins ruled that simply remaining silent isn't enough. You must explicitly, clearly, verbally invoke your right to remain silent and your right to an attorney. If you just sit there silently without invoking, any eventual statements you make are admissible. If you talk without invoking, everything is admissible. You have to use the specific words. Post-arrest statements become the centerpiece of prosecution cases. You say, "I only had one beer 3 hours ago." Prosecutors establish you operated a vehicle after consuming alcohol. They bring in a toxicologist who testifies that one beer means measurable blood alcohol content. They argue that if you're lying about the quantity, you must have been more impaired than you're admitting. Everything you say gets twisted into ammunition against you. The interrogation psychology is sophisticated. Officers are trained in techniques designed to get you talking. They minimize the situation. This happens all the time. It's not a big deal. They suggest cooperation helps your case. The judge looks favorably on people who are honest. They imply they're on your side. "I'm just trying to help you here." None of it is true. Prosecutors will use every single word to maximize charges and push for maximum penalties. Here's the exact dialogue, and this is non-negotiable. The moment an officer starts questioning you after arrest, you say these words and only these words. "I am invoking my right to remain silent, and I want an attorney." If they say you're not under arrest, just having a conversation, you ask, "Am I free to leave?" If they say no, you repeat, "Then I am invoking my right to remain silent and I want an attorney." If they say an attorney can't help you right now, you say, "I am invoking my right to remain silent and I want an attorney." You repeat this exact phrase no matter what approach they take. They might try 10 different tactics. Your response never changes. Why does this work? Because once you invoke both rights, silence and attorney, questioning must stop immediately. Miranda versus Arizona established this foundation. Edwards versus Arizona reinforced that once you invoke your right to counsel, officers cannot reinitiate interrogation. If they continue questioning after you've invoked these rights, anything you say becomes inadmissible. The protection is absolute, but only if you actually use the words. Staying silent without invoking doesn't protect you. Talking without invoking destroys you. You must explicitly invoke both rights clearly and then maintain absolute silence. Here's what connects all 5 mistakes into one systematic process. Building a DUI case requires your cooperation at multiple stages. Officers need your voluntary statements about drinking. They need your performance on field sobriety tests. They need your consent to preliminary breath screening. They need permission to search your vehicle. They need your post-arrest statements. Every single time you refuse to provide evidence against yourself, you force them to rely on objective, observable facts instead of your voluntary admissions and cooperation. Without your answers to the drinking question, they can't establish that you consumed alcohol. Without field sobriety test performance, they lose significant evidence of impairment. Without preliminary breath results, they can't claim a positive screening justifies arrest. Without vehicle search consent, they can't go fishing for additional charges. Without post-arrest statements, prosecutors have far less ammunition. This is why you need to memorize 4 critical phrases right now, today, before you ever need them. First, "I'm not discussing my day, officer." Second, "I do not consent to searches." Third, "I respectfully decline field sobriety tests." Fourth, "I am invoking my right to remain silent and I want an attorney." Write these down. Print them out. Practice saying them out loud until they become automatic, because in the high-stress environment of a traffic stop with blue lights flashing and an officer standing at your window, your brain will not think clearly. Your instinct will be to cooperate, to explain, to prove you're innocent. But if you've practiced these phrases beforehand, they'll come out naturally, even under pressure. That practice could be the only thing standing between you and a DUI conviction that destroys your life. If you made it this far, you understand something that most Americans will never learn. DUI stops aren't about accurately determining impairment. They're about systematically manufacturing probable cause through psychological tactics that exploit your ignorance of constitutional protections. Police training manuals literally teach these techniques. Body camera footage documents them being deployed successfully thousands of times every single day. Court files are filled with cases of sober people who got arrested, charged, and convicted because they didn't know the 4 phrases you just learned. This isn't theory. This isn't paranoia. This is documented reality, and it's happening right now in every state, in every jurisdiction, to people who think honesty and cooperation will protect them. It won't. Only knowledge protects you. Only understanding your rights and knowing exactly how to invoke them gives you any defense against a system designed to extract confessions and build cases regardless of actual guilt. Subscribe to this channel right now if you want to stay ahead of this. Turn on notifications. Share this video with everyone you know who drives, because these exact tactics are being used on innocent people every single night across this country. This channel exists to give you the legal education that the system hopes you never get, the constitutional framework that turns the tables from you providing evidence against yourself to officers having to build cases on actual facts. Hit subscribe, drop a comment about which mistake you didn't know about before watching this, and understand that what you just learned could literally be the difference between going home and going to jail the next time you see blue lights in your rearview mirror. Cooperation does not mean conversation. Protecting your rights is not obstruction. And knowing the law is the only defense that actually works when the system is working against you. Stay informed, stay protected, and remember, constitutional rights only protect you if you actually know how to invoke them.